Please report.
Yes, Mr. Lister.
Counsel, Mr. Kent, Mr. McCullough, Mr. Swirling. Ladies and gentlemen of the jury, what is the value of a human life? To grieving parents who've lost a 14-year-old to senseless acts of violence, a human life is priceless. But on May 28, 2023, Rick Chow, the defendant in this case, determined that Cyrus Carmack-Belton's life was worth less than 4 bottles of water. I say this because in May of 2023, Rick Chow, the defendant in this case, was the owner of a convenience store and gas station on the corner of Park Lane and Springtree here in Columbia. His wife was working that evening. She was a co-owner, and their adult son was working there as well that particular evening. It was around 8 o'clock or so p.m. that Cyrus Carmack-Belton, a 14-year-old, walked into that store. And he had on a red hoodie with a small pocket in the front. He was carrying a black backpack. We know this to be true because the defendant in this case, Rick Chow, had an intricate camera system that captured almost every interaction within that store and multiple camera angles. He also had camera angles outside of the store on the premises of the store and immediately adjacent to the store so you could see what happened at the beginning of Springtree as his property ended. So Cyrus walked into that store, red hoodie, small pocket in the front, black backpack, and he walks in and he immediately is asked by the co-owner, Alice Chow, to remove his backpack. That's store policy. Cyrus complies, does exactly what he's asked to do. He puts that backpack on the cooler and begins to walk around and browse throughout the store. He goes aisle to aisle, browsing, looking around, looking at the candy, looking at the waters, looking at other things in the store. And Alice is directly behind him watching everything that he does. When he walks to the front of the store, she watches. When he walks to the side of the store, she watches. She leans against posts and watches everything that he's doing as he walks through that store. Their adult son Andy is working the counter, and he's watching as well. And as other customers come in to buy things, he'll service them and continue to watch Cyrus as he walks through the store. Finally, Cyrus walks to that back right corner of the store. And again, we know this to be true because of that intricate camera system that Mr. Chow installed. He walks to the back. He opens a water cooler, leans the water cooler against his left shoulder, and takes out 4 bottles of water. 1, 2, 3, and 4. And after a second, he pauses and methodically puts all 4 water bottles back into that cooler. 1, 2, 3, and 4. He closes the cooler and begins to walk back towards the front of the store. And it's at that point that the verbal confrontation begins. And I say confrontation because Cyrus said nothing. The co-owner of the store, Alice Chow, asked if he needed help and eventually accused him of stealing water, told him to empty his pockets. The adult son, Andy, who was watching, said the same thing. You took some water. Give us back the water. Cyrus said, I took nothing. I didn't take anything. I didn't take anything. And they continued to verbally attack him, accusing him of stealing water. Interestingly enough, if you look at that intricate camera system, Cyrus is telling the truth. He took nothing from that store that day. As he tried to walk out of the store, they continued to verbally harass him to the point where he took his backpack and calmly walked out of the store. Again, we know that to be true because of that intricate camera system that Rick Chow installed. And as he walks toward that door, the co-owner, Alice Chow, says something in Cantonese that makes her son run around the counter towards Cyrus. And then Rick Chow, the defendant in this case, comes from out of an office in the convenience store, armed with a .45 caliber Glock pistol. and follows Cyrus out of that store. Cyrus walks out of the store, takes a right, slowly, and hears them yelling, running after him. Turns to see, and again, the camera system shows these things, and he takes off running. Cyrus tries to run through the parking lot to the point to where he runs out of his Air Force One Nike shoe. Runs out of his shoe. Doesn't turn around to pick it up because you have an adult male running behind you with a .45 caliber Glock pistol who has falsely accused you of stealing. So he runs. He drops 2 cell phones out of his pocket. We know this to be true because there are witnesses who we expect you'll hear from who'll talk about how they had to throw on brakes to keep from hitting them as they ran across traffic. We know this to be true because of that intricate camera system that he installed. He drops 2 cell phones. One belonged to him, one to his mother. Doesn't turn around to pick up one of those cell phones. Continues to run, falls down, gets back up running, falls again, busts his shin, drops the backpack, keeps running. In total, Rick Chow and his son chased Cyrus Carmack-Belton over 130 yards off of their property onto a public road in Columbia, South Carolina. And eventually, after Cyrus fell a couple of times, Rick Chow fired the fatal shot, which ended his life. Folks, 130 yards is a football field. No, in fact, it's a football field goalpost to goalpost plus 10 yards. Ladies and gentlemen of the jury, I'm Byron Gibson, the 5th Judicial Circuit Solicitor, and I, along with Dale Scott, Stephanie Taylor, and Weston Leifer, represent the state of South Carolina. So for the next few minutes, I'm going to give you a little bit more of a roadmap of what this case entails, what our position is in this case, and what we believe we can prove, as well as give you an idea of what to expect from the court and how this proceeding will run for the next several days. Now, I mentioned to you a moment ago that when Cyrus walked into that store, he was wearing a red hoodie and a pocket in the front, black backpack. Unbeknownst to the Chow family, to Rick Chow, to Alice Chow, or to Andy Chow, he had a pistol in the front pocket of that hoodie. Unbeknownst. They didn't know. We know that to be true because that video will confirm all of those things. Confirm that he walked around the store, had a conversation with them. At no point did he ever threaten them. At no point did he ever curse them when he was being falsely accused. He didn't spit on them. He never attacked them. He calmly walked through the store and calmly denied stealing anything from that store, which again was true. The truth in this case is that Cyrus did what you'd expect an adult to do in that case. He walked away. He tried to create distance every time he was confronted. But for some reason, Rick Chow wouldn't believe him. He couldn't believe him for some reason, although the evidence will show that he took nothing from that store. The evidence will show that after they chased him out of his shoe, dropping phones around down Springtree Road, after he tripped over a curb, fell, dropped his backpack, we believe that gun spilled out of that pocket. And within moments after that gun spilled out of that pocket, that man shot Cyrus Carmack-Belton in the back with a .45 caliber pistol. Now, we believe evidence will show that soon after EMS and others came on the scene, Rick Chow tried to say, hey, I was defending my son. But the interesting thing about this process is that you're going to have an opportunity at the end of this case, that you've heard all of the evidence from this witness chair, to assess what you've learned and what you've heard. You get a chance to assess that, and I'll ask as you start asking those questions that bounce around in your head. In what world do you get to falsely accuse a 14-year-old of stealing, chase a 14-year-old 130 plus yards down a road while you're armed with a pistol, shoot that person in the back, then claim you're defending your son? Folks, it's for that senseless act, for that ridiculous act, for that heinous act that Rick Chow, the defendant in this case, has been charged and indicted with the crime of murder. And it's for that crime that we, the prosecution, Dale Scott, Stephanie Taylor, and Weston Leifer, will be asking that you return a verdict of guilty at the appropriate time. Now, as prosecutors, we have something that's called the burden of proof. And what that means is we have to prove beyond a reasonable doubt that Rick Chow murdered Cyrus Carmack-Belton. Now, reasonable doubt in South Carolina, our courts have defined it a couple ways, and I'll explain those to you. Reasonable doubt is the amount of doubt that causes a reasonable person to hesitate to act. The amount of doubt that causes a reasonable person to hesitate to act. There's an alternative definition that says that if you are firmly convinced of a defendant's guilt, then at that point they are guilty of a crime. But that's for you all as the jurors to decide. Now, as was mentioned a few moments ago, Judge Taylor is the judge of the law. And you've got to take the law as he gives it to you. So at the appropriate time, he'll advise you of the definition of reasonable doubt and every other legal standard and every other thing about the law that you're going to need to know. He'll advise you of those things at the end of the case at the appropriate time. But the cool thing about this process, just as he said, is that as Judge Taylor is the judge of the law, you guys are the judges of the facts. And you get to determine based on what you hear from this witness chair and the evidence that you observe, you get to determine what actually happened in this case. So you're probably asking, all right, well, how am I supposed to do something like that? How am I judging people about, as a witness? I suggest to you that just as you are judging my credibility and believability right now, that's a skill that you've developed over all these years that you've been walking this earth. I suggest to you that when you parked your cars this morning, you didn't leave your common sense in the parking lot. That's what you're using to assess credibility and believability. And that's what you'll be doing with each of the witnesses that comes up here. You'll judge that. You'll talk. You'll have an opportunity to determine if they had motive to say what they say, if they could observe the actual things that they're saying they observed. If they have some reason to change or to try to tell a story in a way that's going to help them. You'll get a chance to make those determinations at the appropriate time. And we'll ask that you do that. A couple moments ago, each of you guys took an oath to well and truly try the facts of this case. And what that essentially means is that you got to try the facts of this case, not some stuff that you may have heard out there, not some preconceived notions, not some ideas that you may have, but from the evidence that you hear in this jury room this week in this case. That's what you've got to do. Folks, I ask that you resist the urge to turn this trial into some type of commentary about youth and guns, because it's not about that. It's about a grown man who falsely accused a 14-year-old of stealing, chased him down the road while armed with a pistol, shot him in the back, and then claimed he's defending his son. That's what this case is about. And ultimately, those are the decisions that you'll have to make at the end of this case. Now, I expect that you're going to hear from several different types of witnesses this week. Some are going to be what we call lay witnesses, just people who just happened to be driving up and down Spring Tree Road that day. Folks who saw what happened. Folks who watched the child chase Cyrus across the street and shoot and kill him. We expect they'll have different vantage points, seeing things in different ways, but you'll have an opportunity to listen to them and assess what they saw. You'll hear from law enforcement, first responders, people who saw what happened and talked to witnesses out there on the street immediately after it happened. Some body cam, meaning the body cameras that they're wearing when they're talking. You'll see some of those things. Take that information. You'll also have an opportunity to hear from a few experts. And judge will explain to you what experts are and what expert testimony is and how you weigh expert testimony. Again, take the law as he gives it to you. And take the law from experts and determine if they have the ability to testify about the things that they say that they know, and how they came upon this information, and if this information was paid for. Ask yourselves those questions at the appropriate time. Now, folks, you're going to hear about 3 types of evidence. I'm wrapping this thing up. I don't want y'all to get sick of me this early in the week. There are going to be 3 types of evidence you're going to hear about. One is direct evidence. Second is circumstantial. Third is stipulations. Direct evidence is evidence that you can see, that you can touch, that you can feel, and sometimes even smell. Circumstantial evidence is evidence that you can infer exists based on a series of facts. All right? Evidence that you can infer exists based on a series of facts. So, example, we're sitting in here, South Carolina, it's probably going to be 80, 90 degrees with 100% humidity. If you walk out here at lunchtime and you see snow outside, it's 12 degrees outside. You see icicles hanging off of the different the posts and all that kind of stuff. You see a snowplow going through here. You see penguin tracks and maybe a polar bear walk by. You are in this room with no windows all day. But you can infer that it snowed because you see all of the evidence of snow. That's circumstantial evidence. It's just as good as direct evidence if you, the jury, determine that you believe that that's what took place. So direct evidence, circumstantial evidence, and last we're talking about stipulations. Stipulations are agreements between our table of state and that table of defense team. They're stipulations. That means we have an agreement that a particular fact exists. And if we have that agreement and we alert judge that that agreement exists, then judge will have the opportunity to explain to you that that's not a fact that you guys have to haggle about or even argue about, because we agree that it's the truth. So direct, circumstantial, stipulations. Those are the 3 types of evidence we'll be talking about. And at the appropriate time, you'll have a chance to look at the facts of the case, and with the evidence, you compare that to the evidence and return a verdict that speaks the truth in this case. Now, my final ask of you is this. There's an 11th century philosopher named Omar Khayyam. And one thing that he wrote back then was, "The moving finger writes, and having writ moves on. Nor all your piety nor wit shall lure it back to cancel half a line, nor all your tears wash out a word of it." Now, I know y'all are looking at me kind of like, what is this dude quoting some 11th century philosophy for? I'll tell you that at the end of this case, I will explain to you why something written back in the 1100s and 1200s rings so true today in this courtroom in 2026 about a case where that man murdered a 14-year-old in 2023. So, folks, remember what we've talked about and ask yourselves one last question. What is the value of a human life? Thank you.
Ladies and gentlemen of the jury, good morning. My name is Jack Swerling. We met briefly yesterday when we were doing the jury selection. And it's my position at this point to go ahead and give you a defense opening statement. And I appreciate you being here. Thank you for being here. And I hope that you find this experience on your part to be an interesting experience about looking into your judicial system. We spent, let me just back up a minute. My good friend, the solicitor, just gave an outstanding opening statement himself. But the one thing that I did not hear, and the one thing that I do not believe you will hear during the course of this trial, is why a 14-year-old would be illegally possessing a semi-automatic pistol, wandering the streets with that pistol, with a laser attached to that pistol, a laser to go ahead and ensure better accuracy when you fired the weapon, a semi-automatic pistol that was loaded, the magazine was loaded, and there was a bullet in the chamber. It was illegally possessed by this young man. He illegally entered the store because there was a sign posted, it's illegal to go ahead and enter the store with a weapon. Versus what Mr. Chow did. Mr. Chow had a concealed weapons permit. He never drew his weapon. He was authorized to have a weapon, but he didn't draw that weapon until his son was in danger of being shot. The solicitors, in this case, want to frame this case. It was all about a bottle of water. It was all about someone wrongly accused of shoplifting in the store. But nothing else matters to the state in this situation as to why this young man had that weapon, why he carried that weapon. Because if he didn't have that weapon, he never would have had a weapon to draw on Andy Chow. He never would have had a weapon to put Andy Chow in danger. And he never would have had a weapon that would cause Mr. Chow to believe his son was going to be shot and have to make a split-second decision as to whether or not to go ahead and fire that gun and protect his son. There's going to be a lot of questions in this case, a lot of things that you're going to have to resolve. But I wanted to go ahead and tell you why this case is framed the way the state is doing it, because they don't want to explain why that young man had a semi-automatic pistol, loaded, bullet in the chamber with a laser, entering the store, wandering the streets. They don't want to explain it, because you know what? They cannot. We went through a jury selection process yesterday that's carefully designed to go ahead and make sure that 12 people who will eventually decide this case, 12 people from Richland County, who are fair and impartial, who do not have any preconceived opinions, who've come in here under oath and said, I may have heard about the case, but I have not formed an opinion about it. I'm willing to listen to the evidence and the law that the judge gives me and decide this case fairly and truly and honestly. We went through a jury selection process where, as you recall, the judge excused a number of witnesses for one reason or another to make sure we had a fair and impartial jury. The state excused witnesses because the lawyers, both sides, are entitled to go ahead and make challenges to witnesses or peremptory challenges. They have challenges that we can exercise because any reason whatsoever. However, what it comes down to is that both the judge, the state, and the defense believe that we have the 12, 13, 14, 15 jurors now who are the most fair and impartial jurors who can sit in judgment on this case and decide whether or not Rick Chow is guilty of murder, whether or not he intended to kill this young man and he did it with malice, an evil heart, a wicked mind. That's what malice, judge will describe to you what malice means. And you will have to decide whether or not the state has proven that case beyond a reasonable doubt. So we are satisfied, we are content that we have the best jurors that could come out of Richland County to decide this case, and we have faith in you. Rick Chow has pled not guilty to this offense, and that places on the state the burden to prove guilt beyond a reasonable doubt. Now, I just want to cover a couple of legal issues, legal principles with you. One is, as he sits over there right now, and throughout the course of this trial, all the way through, he is presumed to be innocent. That's not just a legal fiction. That's not just something you hear on TV and Law and Order or some other one of the great police shows or law enforcement shows on TV. The presumption of innocence is the bedrock of our judicial system. Everybody accused of a crime is presumed innocent unless and until the state proves guilt beyond a reasonable doubt. That presumption of innocence is so strong on our law that you are to consider and presume Mr. Chow innocent unless and until, at the end of the case, after you've heard all the evidence, after you've heard the judge's instructions on the law, you go in the jury room and 12 of you agree, 12 unanimously agree, that the state has proven guilt beyond a reasonable doubt. That presumption of innocence does not disappear during the course of this trial. Now you may say, well, that's kind of difficult. It is our law. It is what makes us different than everybody else on the face of the earth. The state has to prove guilt beyond a reasonable doubt, and until you go in the jury room and decide that the state has met its burden of proof, he's presumed to be innocent. Now, proof beyond a reasonable doubt doesn't just mean any doubt, but you have to prove the case beyond a reasonable doubt. In other words, I believe, or I think, maybe, any one of these words, that is not enough to go ahead and convict someone. It has to be beyond a reasonable doubt. It's not enough to say, you know, I think the state met its burden of proof. I think the state proved guilt. I mean, that's not enough. It's beyond a reasonable doubt. And the reasonable doubt can come from the evidence or the lack of evidence. Either way, you are the ones who determine whether or not the state has met its burden of proof, proving the case beyond a reasonable doubt. You're the ones that apply the presumption of innocence. Not the judge, not the lawyers, not the parties, but you. The state also has a burden of disproving self-defense. And this is a case of, it's a collateral issue to self-defense, whether or not someone has a right to exercise self-defense and take another human life. Self-defense is probably the oldest principle we have as man. All the way back. You have a right to defend yourself. You do not have to wait and someone goes ahead and shoots you, or kills you, or stabs you, or no matter what it may be. It is elementary, it's fundamental that a person has a right to exercise self-defense, the law of self-defense, to defend himself or herself. And it also applies to defense of others. Same principles. You are entitled to go ahead and defend other people in a similar situation. For example, your son, which is exactly what we have here. Because if the state doesn't prove beyond a reasonable doubt that Rick Chow did not act in self-defense or defense of others, then they fail. They have failed to prove the case. There's no burden on any defendant to prove anything in the case. So the state has to prove guilt beyond a reasonable doubt, and they have to disprove self-defense or defense of others beyond a reasonable doubt. And we know that you're going to hold them to that burden of proof and keep our system the way it was designed to be. That a jury sits between the state or the federal government and the citizens in a county or in an area and decides cases fairly and impartially, and that no person is ever held to answer for a crime where the state has not met its burden of proof. The judge will describe to you what the definition of murder is. And I told you it's malice aforethought. That's what South Carolina standard is. Murder is with malice aforethought. You kill somebody with malice aforethought, that evil heart, that wicked mind. The offense of murder also requires, as the judge will tell you, a criminal intent. You have to have a criminal intent to go ahead and be guilty of a crime. You have to intend the crime. And the judge will explain that to you at the end of the case as well. And I'm not going to go into the details of it, but I just want to turn these principles over to you so you know what we're talking about. Self-defense, defense of others. Was there a reasonable belief or an imminent danger? Was the imminent danger, and you believed it was reasonable, and it was reasonable, that someone's life was in danger, your own life or the life of a loved one, like Andy Chow? Under those circumstances, you are entitled to go ahead and exercise that self-defense or defense of others. And the judge will explain to you, as I just said, that it is up to the state to disprove that. You will hear evidence of that. You will hear in detail exactly what happened out there on that street and what happened when Rick Chow went ahead and fired the shot. The young man was pointing a gun at his son. Defense of others. Is that an immediate threat, an imminent threat? Is it a reasonable belief that your son is in danger of serious bodily harm or death? I submit to you there's not going to be any question about whether or not it was reasonable or whether it was imminent, or it was reasonable to believe it was imminent. And you are, under the law, since the beginning of time, allowed to go ahead and take, unfortunately, nobody's saying this is, everybody's happy about this, but unfortunately, there are occasions in human life when someone has to exercise that right of self-defense or defense of others, and another life is taken. It's sad, it's tragic, there's no question about that. My heart goes out to the family. They've suffered a tremendous loss. And I don't want you to think for 1 minute that we're making that light about that. This was a terrible situation that happened, and that young man is no longer with us. But there are legal issues that you must decide prior to making any determination about guilt. And I submit to you right now, that the state will not and cannot meet its burden of proof, proving guilt beyond a reasonable doubt, proving murder, malice aforethought beyond a reasonable doubt, criminal intent beyond a reasonable doubt, or disprove the defense of others, as a judge will explain it to you. Now, how do you decide that? Well, you're going to listen to the evidence. You're going to hear the law by the judge, and you're going to make your decision based upon that evidence that you hear and the law that the judge gives you at the end of the case. There's no schooling. We don't have any classes to how to go ahead and determine that. But I will tell you this. Reasonable doubt is something you use and exercise every single day when you make the important decisions in your life. Should I go to that school? Should I buy that car? Should I buy that house? Do I need this? Do I need that? You weigh the factors, both the pros and the cons. And no matter what the pros and cons are, you're still entitled to go ahead and make that purchase or go to that school or go on that trip, even if it all adds up to being not the right thing to do. But when you come into a courtroom, it's completely different. Because if you have a reasonable doubt, if things just don't make sense, if it doesn't add up, one thing after another make sense, and come to a conclusive decision that the state has proven guilt beyond a reasonable doubt, you can't disregard that. The oath that you just took requires you to find someone not guilty or not proven is another way to look at it. Not proven beyond a reasonable doubt. Submit to you at the end of this case, again, hearing the law and the evidence or the lack of evidence, you will come to that decision that the state has not met its burden of proof as to proving the case or disproving self-defense or defense of others. You look at the evidence, you listen to the witnesses. Are they consistent? Have they told the same story, the same, everything that they've seen, everything that he did, is it consistent all the way through? Not only is it consistent between what they said, but consistent with what other people said. And not only consistent with what other people said, but is it consistent with the physical evidence that you know and that you see and is presented to you in the courtroom? You look at motive and interest and bias and prejudice to decide whether or not to believe a witness or the credibility of witnesses. You are the folks that decide the credibility of witnesses. I want to go ahead and, as I've said, it's a tragic situation. My heart goes out to the family that they've lost a terrible loss, and nobody can understand that. Nobody can in any way comprehend what it would be like to go ahead, and I feel sorry for these folks. And I feel sorry for the young man who lost his life. But it's also about the Chow family. Rick Chow and his wife Alice Chow. Rick was born in Hong Kong. Alice was born in Malaysia. They came here early on in life as students. They went to Louisiana, University of Louisiana. Rick Chow and Alice Chow became citizens of the United States, as proud American citizens as anybody could possibly be. They married. They had 2 children, Andy and Kenny, who've both gone to the University of South Carolina. Alice was a CPA, earned her CPA degree and a license. Rick Chow was a professor at Upper State Carolina for a number of years in computer science. These are motivated, energetic people who wanted to pursue the American dream, and they did. At some point, they wanted to go ahead and own a business, and that's how they came to buy the store that's in question today. They had that for about 10 or 12 years. They bought it as a Shell gas station. And they bought the store, and they operated it. Rick Chow really wanted to go ahead and form a business. So for 10, 12 years, they've operated that business. In May, as the solicitor has told you, the situation that's before you today, young man, Carmack-Belton, entered their store. Now, when he entered the store, he had a backpack. Backpacks have to be put on the water cooler. It applies to everybody. They don't want anybody walking around in the store with a backpack. So everybody puts it on the water cooler. Mr. Belton Carmack did. Put it up. You will find out, we'll talk about what's in that book bag later on, but the young man entered the store, walked around, all around the store, not buying anything, looking at different merchandise, not buying anything, going to the water cooler, strangely removing 4 bottles one at a time, then strangely putting them back one at a time, looking nervous, his hands in his pockets, looking back at Andy Chow, looking back at Alice Chow, who was on the floor at that time. They were both in the store, in a nervous way. and they had a suspicion that he possibly had shoplifted something. Now, this is a store with thousands of small dollar items. A water bottle or any other item in the store, probably very little profit in it. So it's not about whether or not one item was ever taken, it's the cumulative effect and the losses that a store owner can feel from that. So they have a right to go ahead and look and see if anybody's taking anything. When Mr. Belton was leaving the store, he was asked, "Did you take anything?" And he basically had his hands in his pockets and he turned it up, the pockets. "No." "Do I look like I have anything?" He was asked again, and at that point, he went to the water cooler, picked up the book bag, and at that point exited the store. There was no physical confrontation. There was no yelling at him, but there was a request, there was a question that he answered, but Andy Chow still felt that there was something about the way he was acting in the store, and he wanted to follow, at least to see where he was going, so they could report that to the police. He could report it to the police. But at that point, when they exited the store, Mr. Belton, Carmack-Belton, started running. Now, he saw something that he thought, Andy Chow saw something and he thought looked heavy in his hoodie, in the pockets of his hoodie. And that could have been something that he took, like the water. Well, we now know that it wasn't the water, but it was a semi-automatic loaded pistol with a laser on it in those pockets. So he was telling the truth, that he saw something heavy in the pocket. The suspicion increased when the young man took off running. Why was he running? Why did he run? He did increase the suspicion at that point by running. And he really ran fast because he ran out of one of his shoes. He threw the phones down before he exited the parking lot. And he just took off as fast as he could. Now, reasonable to believe that he may have taken something? Absolutely. Reasonable to go ahead and follow him to see where he was going, in what direction, so he could tell the police? Absolutely. And he wasn't going to tackle him, he wasn't going to hold him, he wanted to see where he was going. Rick Chow had come out of the office, and he saw his son outside, and the young man outside as well, and he saw him both of them take off running. Rick Chow, the defendant in this case, ran following his son and Mr. Carmack-Belton because he was trying to see what was going on with his son, protect his son, make sure his son was okay. He did not know what was going on. He had nothing to do with the determination in the store, but he was going out there to protect his son, to make sure his son was okay. It's his son! The young man hauled down the street, crossed over the street, ran down on the left side of the street toward the apartment complex. And at some point, he tripped, fell. Mr. Chow was behind him. Andy was somewhere, and you'll hear the testimony about it, somewhere in that area on the street. And actually, the young man hurt his leg, cut his leg. But when he got up, and by the way, he also threw his book bag into a ravine down there. Why? Do these things increase suspicion? Absolutely. It would increase anybody's suspicion. But when he came up, and Andy Chow saw that he had a pistol in his hand. It turned out to be the 9mm pistol. That one in the chamber was loaded and it had a laser that had been attached to it, but the laser was found in the road, right near the road where the shell casing that was fired out of Mr. Chow's weapon landed. Now, Mr. Chow never pulled out that weapon. The state wants to talk about, well, you know, he ran from somebody who had a .45 automatic, semi-automatic. How would the young man know that? He didn't even see Mr. Chow. Mr. Chow had it in a holster the whole time. He did not pull out his weapon from the holster until
I apologize. Just objects.
All right, overruled. Go ahead, Mr. Work.
he didn't pull out his weapon until he was told by his son that the young man had a gun. The young man, Andy being a young man as well, when he saw the gun, started backing up like this, had his hands up, backing up into the street. Mr. Belton pointed the gun at Andy Chow. Mr. Chow told him, drop it. He didn't drop it. Andy yelled out, he's got a gun. He's standing in the road. Mr. Chow is coming up. Pulls his gun now. At that moment, at that split second, that frozen moment in time, Rick Chow sees a young man pointing a semi-automatic pistol at his son, who's backing up with his hands up, and Rick Chow fires his gun to protect his son. We submit to you that that was reasonable. It was a reasonable impression that his son was possibly going to get seriously injured or die at the hands of somebody who had a gun pointed at him, that that was a reasonable belief, and he fired his weapon under the law in defense of his son. As I submit to you, anybody in this courtroom, now you will hear a testimony that's consistent with that. What I'm telling you right now, it's consistent with what has been said in this case by the witnesses. And you will hear testimony from various people that you will find is consistent with that, that version of what I just told you is consistent. There's no question that that gun belonged to this young man. There's no question that that young man had that laser on that gun. As a matter of fact, you will see evidence. We submit that we'll be able to lay a foundation in our defense that he was on social media the night before wearing the same clothes, holding the same gun with a laser. There's no question about it. You'll be satisfied at the end of this case as about the direction everybody was, where everybody was placed, the direction where Mr. Chow was when he fired the weapon, where his son was, and where Mr. Carmack-Belton was. All of that, I submit to you, will be consistent. Mr. Chow did not take any joy in what happened. It was chaos. Adrenaline's pumping. Can you imagine what you're thinking about when you had to go ahead and take that action to go ahead and, first of all, see your son with a gun being pointed at him by a 14-year-old, and then having to fire the weapon to protect your son? What was going through his mind, what was going through his heart, what was going through his head, wasn't something he did because he wanted to. He did it because he was trying to protect his son. But the state doesn't talk about the gun. The state doesn't offer any explanation or rationalization as to why that young man pulled that gun and was walking around with that gun in the streets of Columbia, South Carolina. Mr. Chow didn't just run away at that point. He rendered aid. He stayed right there at the scene. He started doing chest compressions. You'll hear that. The young man was regurgitating. Terrible things, terrible scene. Mr. Chow was bending down, cleaning his mouth out, and giving him mouth-to-mouth resuscitation. You'll hear that. This is a man who acted with malice. This is a man who acted with criminal intent. I submit to you not. This is a man who was deeply upset about what happened, to the point that he was doing some things that I wonder how many people would have been doing exactly what he's doing to try and save this young man. And then other people came over. But Rick Chow stayed there, did chest compressions, took vomit out of his mouth with his own mouth so the young man could keep breathing. And then other people, more qualified people, were able to go ahead and try and help the young man. Unfortunately, he died. Unfortunately. Mr. Chow stayed around, stayed at the scene. He was there when the police came, told the police what happened, gave a brief description. It was not an interrogation, it was not an interview, it was not a complete, what I would call an interview by law enforcement, but there were snapshots taken of different people, Andy Chow, Rick Chow, some of the people who were at or around the area there. He stayed there that entire time, went back up to the store, and when the police came up to the store, he showed the police the videos that they had. He was cooperating 100%, doing everything he could to not only save the young man's life, but also to cooperate with the police. Everything he could. His wife was doing the same thing. His son was doing the same thing. These were not people who had any kind of joy in what had happened. They were upset. It's terrible. Not as bad as, obviously, the parents of this young man. Not nearly to that level. But having shot somebody and having someone die, it's got to be something that's just so difficult to go through. When he agreed, they gave over all the videotapes to the law enforcement as well that were in the store. They all agreed to go down for further interviews at the sheriff's department over the course of the next few days to give a real interview as to what happened bit by bit, word by word. But within 15 hours, before any of the investigation really had focused with detailed interviews, with forensics things from the labs as to whatever, ballistics, DNA, whatever the issues were, within 15 hours, when Mr. Chow was called down, he was told to report to the sheriff's department. He could be placed under arrest for murder. That's how long it took, 15 hours. Ladies and gentlemen, I again say this to you. The state wants to frame this as a situation where a young man may have taken some small item from a convenience store, wrongly accused, chased, and he wasn't chased, he was followed, chased and shot down because he had taken something from that convenience store. I submit to you it's not that simple. You can't frame it like the state wants to frame it. Andy Chow had a reasonable belief that something took place in the store. He followed the young man out. Rick Chow had a reasonable reason to go ahead and follow his son to see what was going on to protect his son. Andy, when he saw the pistol being pulled, as the solicitor pointed out, 130 yards down the road, he started backing off with his hands up, and his father saw that pistol being pointed at his son with and by a 14-year-old young man. He had to make a split-second decision to go ahead and defend or not defend, fire or not fire, to protect his son, his pistol. What should he have done? Because that's what the state is trying to get doing Monday morning quarterbacking. That's what it's all about now. I submit to you, and I'm going to sit down in a moment, and I appreciate you listening. There are 3 questions in this case. One of them is no particular order. But what was the 14-year-old doing walking around Columbia with a semi-automatic 9mm weapon in his book bag, in his hoodie, with a bullet in the chamber, illegally possessing that weapon, illegally walking into a store that barred people coming in with weapons? Another question is, would any reasonable person believe that their son was in imminent danger of death or serious bodily harm such that they had to exercise the right of self-defense? And what would any reasonable person, the third question, what would any reasonable person do under the same circumstances? Fire or not fire? That's something that everybody's going to have to think about. Mr. Chow told him to drop the gun. He didn't. Mr. Chow had the gun in his holster. He didn't pull it out until he saw it, or his son said he's got a weapon. Again, he made that split-second decision. There was no malice. It doesn't even fit the definition of what murder is in South Carolina. With malice, protecting your son. No criminal intent. Fired one shot, stayed there, tried to render aid, life-saving aid, and cooperated with law enforcement. Stayed on the scene. Agreed to further interviews. Then was arrested within 15 hours. Quick decision. I'm going to sit down now, and I do appreciate you listening to me. I submit to you there's one scenario more frightening than a man walking around the streets of Columbia with a pistol, semi-automatic pistol, one in the chamber, just walking around town with a laser on his gun. There's one scenario more dangerous than that, more frightening than that. Is a 14-year-old walking around town with a semi-automatic pistol, loaded, chambered, with a laser on his gun. How frightening is that? A 14-year-old does not have the education, the training, the experience of making good decisions, sound judgment decisions. That is more frightening than anybody in that same situation. And that's what Rick Chow and Andy Chow were faced with that day. I challenge the state at this time to offer some justification or rationalization as to why this young man illegally possessed a semi-automatic pistol with a laser and entered a store with that. Whether the merchants knew it or not, that is not the issue at this point. But why? You're entitled to know why. At the end of the case, we hope that you will find that they have not met their burden of proof in proving guilt beyond a reasonable doubt for the evidence or the lack of evidence, and that they have not disproved beyond a reasonable doubt that Rick Chow acted to defend his son's life, and it was reasonable because it was an imminent danger to his son of death or serious bodily harm, or he reasonably believed that. Thank you.